Rather than waste any time, we're going to get right into evidence from BARBRI's materials. And we're just going to start with the introduction. Overview of evidence. What is evidence law? The law of evidence is a system of rules and standards that regulate the admission of proof, evidence in a court proceeding. In other words, the important facts of the case are determined by proof that is filtered through the applicable rules of evidence and determined to be either admissible or inadmissible. This proof includes testimony, writings, physical objects, and anything else presented to the senses of the jury. Such proof can be direct or circumstantial in nature. 1.1.1 How the rules work together. Most of the evidence rules describe when evidence is inadmissible. For example, irrelevant evidence is inadmissible, most hearsay is inadmissible, and so forth. This means that if just one objection is sustained, the evidence is inadmissible even if all other objections are overruled. Think of a hurdles race at a track meet. The runner must jump over every hurdle to cross the finish line. What law controls on the bar exam? Multi-state bar examination, MBE. The federal rules of evidence govern the NBE. Essays on the California bar exam can test on the federal rules and or California law. If the essay question tells you what the law applies, just follow the directions, meaning if the question tells you to apply California law, then apply California law. If the question tells you to apply the federal rules, then apply the federal rules. If the question doesn't tell you what law applies, then apply the federal rules. Just taking a short break here while I see if I can read out loud. It says I can't. It says that permissions don't allow me to read out loud. So, applicability of federal rules in federal courts. We know that the federal rules control on the MBE and on some essays, but you might encounter an exam question about whether they apply in a particular federal proceeding. The federal rules are generally applicable in all civil and criminal federal proceedings. However, there are certain types of proceedings listed below where the judge or jury is permitted to consider more information than would be admissible under federal rules. When federal rules do not apply, except for rules relating to privilege, the federal rules do not apply in 1, the court's determination of the preliminary question of fact relating to the admissibility of admissibility of, I don't know. Admissibility under the federal rules is what we're trying to say. Next section, when federal rules do not apply, except for rules relating to privilege, the federal rules apply when in 1, the court's determination of a preliminary question of fact relating to The admissibility, will cover this in the final module on procedural considerations. 2, the grand jury proceedings. And where was I? 3, other miscellaneous proceedings. And what? Including those involving sentencing, extradition, bail, and probation. So page 3, relevance, 2.1, general rule of admissibility. Before we define relevance, let's discuss why it's important. Irrelevant evidence is always inadmissible, meaning relevance is the initial hurdle for all evidence. Relevant evidence is admissible unless one, it is kept out by some specific rule of evidence that you will be learning about in subsequent modules, hearsay, privilege, public policy, exclusion, etc., or the court uses its 403 discretion to keep it out. We will cover the court's discretion in this module. In other words, irrelevant evidence is inadmissible. And relevance defined. Evidence is relevant if it has any tendency to make the existence of a fact that is of consequence to the determination of an action more probable or less probable than it will be without the evidence. So that's a good one to memorize, right? Any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. That's your definition of relevance. This is sometimes referred to as logical relevance. Let's go over the important components of the definition in more depth. Of consequence, for evidence to be relevant, it must be offered to prove a fact of consequence in the case. Hypo 2A, defendant testifies in a breach of contract action. When he said, "I accept your offer," he secretly was joking and had no subjective intent to enter the contract. Relevant. 2.2.2, more probable or less probable. For evidence to be relevant, it must make the fact of consequence more probable or less probable. So there's already another hypo. Murder prosecution witness testifies he saw defendant holding a gun shortly before the fatal shooting. Relevant? Question mark. In an answer to an essay question, even if the evidence is clearly relevant, don't forget to say so and explain why. So we're still alive. Just not needing the work computer to continue recording. So 2.2.3, distinguish relevance from probative value. Evidence is either relevant or not relevant. It is yes or no proposition. In contrast, the probative value of the evidence is a matter of degree, meaning relevant evidence can have low probative value or high probative value. This is important to the next topic we'll be discussing. Hypo 2C. Before the defendant testifies and admits he was holding a gun before the shooting. Prosecutor later calls a witness to testify to the same fact. Relevant? That's the probative value. What's the probative value? Court's discretion to exclude relevant evidence. Rule 403. Even if the evidence is relevant, the judge has discretion to exclude it if its probative value is substantially outweighed by the danger of one or more of the following considerations: unfair prejudice, confusion of the issues, misleading the jury, waste of time, undue delay, and needless presentation of cumulative evidence. Oh my gosh, I have a headache. This is sometimes referred to as legal relevance standard, or court's 403 discretion. Examples of evidence that presents a danger of unfair prejudice include particularly gory photos or evidence that a defendant has committed other inflammatory acts in the past, or evidence that is admissible when offered for the purpose but admission for one purpose but admission inadmissible when offered for a different purpose. The court must weigh the probative value against the degree of unfair prejudice or other dangers listed above and make a determination as to whether the danger substantially outweighs the probative value. Under the federal rules, fair surprise is not a valid ground upon which to exclude relevant evidence. Note, you'll encounter a new isolated, a few isolated situations where the judge must use a different balancing test to determine whether evidence is admissible. But Rule 403 is the standard balancing test for most evidence. Similar occurrences. When evidence involves some time, event, or person other than that involved in the present case, it is usually inadmissible. The rationale is that the evidence is either irrelevant or does not survive the Rule 403 balancing test. In other words, the relevance is weak to begin with, and the probative value is substantially outweighed by pragmatic considerations, for example, the dangers of confusing the issues, misleading the jury, or wasting time. What else? Despite the general rule above, some recurring situations have produced concrete rules that may allow prior similar occurrences to be admitted. Similar accidents or injuries caused by same condition. Evidence of prior accidents or injuries caused by the same event or condition and occurring under substantially similar circumstances is admissible to prove 1, the existence of a dangerous condition, 2, that the dangerous condition was the cause of the present injury, and 3, that the defendant had notice of the dangerous condition. If the other accident occurred before the plaintiff's accident, and here's a hypo. I hope they give the same accident hypo. Plaintiff had roadkill nuggets at a chain fast food restaurant. He got sick and was rushed to the hospital. He sues the restaurant to prove that the food causes illness. Plaintiff testifies that the food poisoning patient in the next bed at the hospital was a person who plaintiff saw eating roadkill nuggets in the same restaurant at the same time. Admissible? ? What if the other person got sick eating in a different location at the same restaurant chain 2 weeks later? Plaintiff's prior accidents or claims. Evidence of the plaintiff's prior accidents or claims is usually admissible. Inadmissible. It all demonstrates that the plaintiff is litigious or accident prone. Hypo 2E, plaintiff falls on the stairs in defendant's building. To show that plaintiff was responsible for his fall, defendant offers evidence that plaintiff fell and was hurt 2 other times in his life. Admissible? ? I don't know why there's no answer. All right, I'm going to stop reading the hypos because there's no answer, so I don't know what I'm supposed to do. Guess. Exceptions for pre-existing condition or prior false claims. However, such evidence might be admissible in certain circumstances. Evidence of prior accidents may be admissible where the cause of the plaintiff's damages is at issue. If the plaintiff previously injured the same part of their body, the evidence may be admitted to show that the plaintiff's condition is attributable in whole or in part to a prior injury rather than the current accident. Evidence that a plaintiff has made a similar false claim is usually relevant to prove that the present claim is likely to be false. 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 Okay, keep going. Previous similar acts to prove intent. Similar conduct previously committed by a party may be admissible to prove the party's present motive or intent in the current case. Action for employment discrimination on the basis of gender. Plaintiff who was denied a job by defendant offers evidence that in 100 other instances when a qualified female applicant applied for a job, defendant always hired a male. Admissible? ? Rebuting claim of impossibility. Evidence of similar occurrences may be admitted to rebut a claim of impossibility. I've heard that one before. Comparable sales to establish value. The value of a property, may be at issue in certain cases, such as a condemnation action, or to prove the amount of damages of a property has been harmed or destroyed. In this situation, evidence of the sale price of property is admissible if it was in the same area or sold at or around the same time. Habit evidence, 2.4.6. Evidence of a person's habit is relevant and admissible as circumstantial evidence that a person acted in accordance with the habit on the occasion at issue in the case. Habit describes a person's regular response to a specific set of circumstances, meaning you must be specific and repeated conduct. The evidence objectively describes the conduct without suggesting anything about a person's morality. I'm going to skip through these typos. Distinguish character evidence. Character describes someone's general disposition or propensity, and it usually conveys a moral judgment. As discussed in character evidence module, this type of evidence is usually not admissible to prove how a person acted during the events of the case. Character evidence versus habit evidence. Character evidence. Sally is always impatient and in a hurry. Bart is a drunk. Jeff is a careless driver. Lara is very conscientious about the maintenance of her car. Habit evidence. On the other hand, Sally always takes the stairs 2 at a time. Bart stops at Charlie's Tavern every night after work and has exactly 4 beers, making him a drunk. Jeff never slows down for yield signs at the end of the street. Lara checks the brakes of her car every Sunday before church. So, routine practice evidence. Habit evidence above involves people, but there is a counterpart rule for organizations. The routine practice of an organization is relevant and admissible as circumstantial evidence that the organization acted in conformance with their routine practice on the occasion at issue in the case. Industrial custom evidence. Evidence as to how others in the same trade or industry have acted in the past is admissible as evidence of the appropriate standard of care to show how the party in the current case should have acted. However, industry custom isn't conclusive on this point. For example, the entire industry may be acting negligently. I just went way too fast. All right, there's a hypo, and then we go to the public policy exclusions. Certain evidence is excluded by the federal rules because public policy favors the behavior involved. For example, we as a society encourage the settlement of disputes and the immediate repair of dangerous conditions. If such evidence were routinely admissible in court, it could dissuade people from doing these things in the first place. Evidence excluded for public policy reasons includes the following, and the first thing you see here is liability insurance. Evidence of a party's insurance against liability for lack thereof is not admissible to prove whether the party acted negligently or otherwise wrongfully. Admissible for other purposes. So evidence of liability insurance is admissible to prove anything else, including to prove ownership or control, if disputed, to impeach a witness, usually to show their bias, or as part of an admission of liability where the reference to the insurance coverage cannot be severed without lessening its probative value as an admission of liability. For example, don't worry, my insurance will pay it off. Hypo 3B. Skipping hypos. So just to cover that quickly, prove ownership or control if disputed, impeach a witness, usually to show their bias, or as part of an admission of liability where the reference to insurance coverage cannot be severed without lessening the probative value as an admission of liability. For example, don't worry, my insurance will pay it off. That's all. Skipping the hypo, subsequent remedial measures, evidence of repairs or other precautionary measures made following an injury is not admissible to prove negligence, culpable conduct, defect in a product or its design, or a need for warning or an instruction. Hypo, please skip. 3.2.1 Admission for other purposes. Evidence of subsequent remedial measures is admissible for any other purpose, including, again, ownership and control, or two, to rebut a claim that a precaution was not feasible, like that impossibility we were talking about, and to prove that the opposing party has destroyed evidence. Personal injury action is in the next hypo. Hypo 3.3, civil settlements and settlement negotiations. Evidence of a compromise settlement or an offer to compromise a civil claim is not admissible in any case to prove or disprove the validity or amount of a disputed claim, or to disprove the validity of or amount of a disputed claim, or two, to impeach a witness by prior inconsistent statement or contradiction, conduct or statements made in the course of negotiating a compromise, including direct admissions of liability, are also inadmissible for these purposes. And what I was just hearing from one of the lecturers was that the entire statement associated with the settlement is inadmissible, including any statements about liability. In the case of insurance, settlement as this, but not in the case of paying medical expenses. So an offer to pay medical expenses, which is another public policy reason, will not actually make inadmissible any statements to the effect of, or to the issue that go to the issue of fault. And the other thing, I guess to note is that California probably has two other applications. I feel like California, I'm not going to assume what California does right now. Civil settlements and settlement negotiations. Evidence of a compromise settlement or an offer to compromise a civil claim is not admissible in any case to Prove or disprove the validity of the amount of a disputed claim or impeach a witness by any prior inconsistent statement or contradiction, conduct or statements made in the course of the negotiating a compromise, including direct admissions of liability, are also inadmissible for these purposes. Note, evidence of settlement is inadmissible to impeach a witness on the ground of bias. Disputed claim required. The public policy exclusion for statements and negotiations only kicks in if there was a claim or some indication that a party was going to make a claim, although the party need not have actually filed suit. Furthermore, the claim must have been in dispute as to either liability or amount. And two cars collide. First driver leaps out of his car, and before second driver can speak, first driver says, "It was all my fault. Should have never let my dog drive. Let's settle." Admissible? No. In that last statement, that stuff about the fault is not admissible when he wants to settle. Although, we're not at a point where settlement negotiations are actually appropriate, so it is admissible according to the lecturer who spoke on this. It is admissible because we don't even know if anybody's injured yet or that there's going to be a lawsuit, so you really can't talk about settlement. You really can't negotiate settlement before anything happens that would suggest a need for it. 3.3.2, limited exception to rule civil dispute with government authority. Under the federal rules, conduct or statements made during compromise negotiations regarding a civil dispute with a governmental regulatory, investigative, or enforcement authority are not included when offered in a criminal case. For example, a defendant's admissions of fact during settlement negotiations with the Securities Enforcement Agency would be admissible against the defendant in a related criminal trial. Plea discussions. The following are generally inadmissible in any criminal or civil case against a defendant who made a plea or participated in the discussions. Offers to plead guilty. Withdrawn guilty pleas. Actual pleas or no contest, nolo contendere, or statements of fact made during any of the above plea discussions. Note, an actual guilty plea not withdrawn is generally admissible in related litigation as the statement of an opposing party. See the hearsay module. 3.5, payments and offers to pay medical expenses. Evidence that a party has paid or offered to pay an injured person's medical, hospital, or similar expenses is inadmissible to prove liability for the injury. However, unlike the situation with settlement negotiations, admissions of fact accompanying such payments and offers are inadmissible. Generally, the most important thing to remember about offers to pay medical expenses is that accompanying admissions are are admissible. Accompanying admissions of facts are admissible. Beware, however, of an offer to pay medical expenses that is also an offer to settle. For example, I pay your medical expenses if you drop the case. In that situation, the more restrictive rule for settlement negotiations applies, meaning any accompanying statements or conduct would be excluded along with the offer. Evidence that may be excluded for policy reasons, and you have a list here, evidence type, and then a column for admissible and inadmissible. So liability insurance, what's inadmissible is to prove negligence or ability to pay. Admissible is to prove ownership or control as impeachment or as part of an admission of liability. That is, or as part of an admission of liability. Subsequent remedial measures to prove negligence, culpable conduct, a defect in a product or its design, or a need for a warning or instruction. I made hot chocolate. To prove ownership or control, to rebut a claim that precautions were impossible, or to prove destruction of evidence. That's admissible as it relates to subsequent remedial measures, but it's inadmissible to prove negligence, culpable conduct, a defect in the product or design, or a need for warning or instruction. Settlement offers and negotiations. What's inadmissible is to prove or disprove the validity or amount of a disputed claim, or to impeach by prior inconsistent statement or contradiction, but everything else is admissible. Last two, offers to pay and payment of medical expenses to prove culpable conduct is inadmissible, but for all other purposes, admissions of fact accompanying an offer to pay medical expenses are admissible. Withdrawn guilty pleas and offers to plead guilty for nearly all purposes and not admissible. So it's inadmissible for nearly all purposes, and it's just not admissible. The withdrawn guilty pleas and offers to plead guilty.